All right, hi everyone. This is Chapter 3 Ethical and Legal Considerations in Counseling for Counseling 2500. So let's start off with the introduction. Counseling is a profession guided by ethics, laws, and professional standards. Associations provide support, increase visibility, and motivate interest in professional identity. So when they say association, that means organizations within the field. Codes and standards are living documents that change with the needs of the public and the client. And when you hear the word living documents, what that means is that it can change and probably will change on a regular basis. Counselors are also subject to local, state, and federal laws as well. Background, basic concepts. So, ethics is a branch of moral philosophy. Ask basic questions about the good life, about what is better and worse, about whether there is any objective right or wrong, and how we know if there is. So when you say the word objective, basically it means that it's pretty much something that's not necessarily very arguable. Okay, that means it's pretty solid in the way it is. And so it's going to be asking those questions whether or not there's a good way or a bad way of certain things. Professional ethics is agreed upon rules, principles, and standards that govern appropriate conduct and define acceptable practices in various professional fields. So when you add the word professional there, it's talking about work, right? Or the area that you will work in, the career path. And so typically every profession that you can think of will probably have a code of ethics that they want you to abide by or follow. Individuals and groups have beliefs about what is right and wrong, about what is ethical and unethical. There's complex ways humans create the interpersonal boundaries and make choices. So what that is saying is interpersonal basically means working with other people, right? So when people start working with other people, there's so many things that could happen, right? Ethical dilemmas are not easily solved because of how life is so multifaceted. So multifaceted is just a fancy word for a lot of different perspectives on the situation. It's kind of like a diamond is considered multifaceted. It has all these different cuts, which makes it, there's multiple ways of seeing it, basically. So, for example, abortion, capital punishment. So that might be something like the death penalty in prison. And then euthanasia, which is assisted suicide for someone who is dying or terminally ill. Okay. When someone joins an association or group, it usually means that the person agrees to follow the ethical standards established by that group. So when you go into, let's say, the counseling field, that means that we're expecting you to behave like a counselor and the counseling code of ethics. Typically, we will go to the ACA, which is the American Counseling Association's Code of Ethics. And there's also the APA Ethical Principles of Psychologists and Code of Conduct as well. Typically, we'll look at the ACA. They are somewhat similar in certain places where they share similar values, right? But you can go and use either one when it comes to any problems that you might encounter in your professional life. Websites are found at the end of the textbook as well, or you can just literally just Google APA or ACA Code of Ethics, and it should pop up for you immediately. All right, mandatory ethics. So mandatory means required, right? Must. So influence and shape in conjunction with legal standards. So along with the laws of the state or the country that you are in, these are things that you have to follow, okay? Aspirational ethics is to promote ethical behavior based on a broad spectrum of aspirations, such as justice and respect for the rights and dignity of other persons. So aspirational, the other word is inspirational. So inspiration is to motivate, right? Aspirational is when you choose to go as high as you can. So for example, Vogue magazine is a fashion magazine where dresses are like $10,000 each, right? So most of us cannot spend $10,000 on a dress, but we want to look like that, we're wearing that dress, or those people who want to wear dresses anyways. So it's aspirational. We know that the most people who look at the magazine is not necessarily going to be able to afford any of that. But we want to maybe go to, let's say, a Walmart or a Target or a Temu or a Shine or Shein or whatever. And we're going to try and buy clothes that might look like that, right? Because we're aspiring to that. So aspiring or aspirational ethics is to promote ethical behavior based on a broad spectrum of aspirations, such as justice, and respect for the rights and dignities of other people. Okay, so virtues are internal moral processes and on who one is. is this the best thing for my client? Okay, so the best thing, right? Not just like the correct thing, but like, is this the best thing that we can do for this person? Principles concern Principles concerned with what one does and implies a certain level of obligation to act in certain ways. So the principles is, what do you have to do? Okay, important to multicultural clientele, but you also need to realize that you need flexibility because not every culture is going to behave in the way that you expect them in counseling because they're coming from a different country or culture or belief system. Okay, now let's talk about laws. Agreed upon rules of a society that set forth the basic principles for living together as a group. So there's two types of laws. There are criminal laws and civil laws. Criminal laws pertain to behaviors which are crimes, such as, let's say, sexual assault or rape, fraud, acts of violence. And there's civil laws, which pertain to people and groups' interests and rights, which are non-criminal in nature, such as, like, let's say, a contract that gets, not honored, personal injury, divorce, and custodial rights. Custodial is, for this one, is who is going to have custody of their children, okay? And then property interests. So those things are not necessarily very dangerous, right? So those would be the civil, but criminal would be the ones that would be considered more dangerous. Malpractice tort is the non-criminal wrong that involves an injury. So that might be careless, reckless, negligent. Negligent means basically you're not paying attention. And sometimes intentional behavior of a third party when the behavior is a proximate cause of injury to another. So there's also, when you harm someone, right? Physical punishment by parents in some cultures are acceptable. So that's a physical harm that's inflicted on a person. But again, it depends on the culture, right? As a child, I was hit. And obviously, I'm not saying anyone should hit anyone. Actually, the research says that if you punish your children with violence, let's say, you actually make them more violent themselves as well. Or in societies where this is allowed and promoted, there's more fighting and stuff like that that actually exists. All right. Based on a general principle that holds professionals responsible for practices that harm clients, there should be predictable, should have knowns. Core tenet is to do no harm. Okay. Ignorance of the law is not a defense for a violation of the law. So this is something that you'll probably hear multiple times, which is, as a professional in the field, you went to education to get training, right? So now you are no longer allowed to say, oh, I didn't know, and then feel and be innocent of this. They're going to say, no, you needed to know because you have a degree in this field. So we expect you to know, and there's no excuse for it. Ignorance of the law is, again, not a defense for a violation of the law. Multicultural competencies, so learning about different cultures, is also an expectation that you have. Child abuse is illegal, and counselors are legally bound to report child abuse, so it's mandated reporting. Counselors are required to break confidentiality to adhere to the law. So there's abuse. Again, you are required to report this. Some cultures, corporal punishment as normative parenting practice. So this is something that you now need to pay attention to, because if you are having a client, or you do have a client who is multicultural in a culture where, let's say, corporal punishment as a parenting practice is legal, what happens there? Okay. It will be depending on each person. And yeah. All right. Counselor is faced with mandatory reporting requirements, advocacy of family members, and being culturally sensitive. Okay, now we're talking about decision-making steps. Guidelines for making ethical decisions. So what happens if you do encounter an ethical problem at your workplace? Number one, you want to identify the problem or the dilemma. Number two, identify the potential issues involved. So what is going on with the situation? Three, review the relevant ethics code. So that is, again, the ACA and the APA. You might also look at the CRC. It really does depend. If you're, let's say, a job readiness counselor, you would actually look at a specific one that's related to also job readiness as well. All right. 4, know the applicable laws and regulations. So depending on what state you live in, you need to make sure that you're doing nothing illegal or nothing illegal is happening. 5, obtain consultation. So that's talking to your supervisor. So if you're an intern, talk to your supervisor about the situation as well. But think about what's going on first and then bring it to your supervisor. But do it all within the same amount of time. Don't just wait like 3 weeks or anything like that. But actually go through and consult with them, request a meeting and talk to them. 6, consider possible and probable courses of action. So what should you do in this period of time? Okay. And then you want to, for number 7, enumerate the consequences of various decisions. So what 6 is, what are you going to choose to do? There might be 2 options that you can choose from. And number 7 is, let's list out what could happen once you choose either one of those methods, right? Let's see what it is. And then number 8 is choose what appears to be the best course of action. So from there, we're going to choose what we think is going to be the best and safest and healthiest for our client. Collaborative consultation is a key component of most ethical decision-making models and allows for multiple views when addressing difficult issues. All right, now choosing to be a counselor and ethical motivations. Wrong reasons to become a counselor would be you need to be in control or be dominant, right? You need to be loved. You need to feel needed. To be a voyeur on other people's lives. Voyeur is just a fancy word of basically kind of like spying or watching other people. Like, voyeur usually are people who like peeping toms that look through a window, right? To be an omnipotent healer. Omnipotent is a fancy word for powerful, all powerful. And so sometimes you're like, oh yes, I'm someone who can fix problems, people's lives, right? Escape one's own life. That means basically you don't like your own life, so you're living through other people's problems and their lives. Or to cure themselves by curing other people. So these are some reasons why the textbook thinks that, it's not so great to be a counselor. Use clients to fulfill their needs, to nurture others, to feel powerful or important, to win acceptance, admiration, respect, or awe. Unethical when counselors are primarily meeting their own needs and imposing personal values in the counseling relationship. So we're hoping that the reason why you want to be a counselor is because you want to help other people reach their goals. Okay, so it's really about your client. You just happen to know the skill set to help them. Right? And so you're going to use your experiences, your skills, yourself to be able to help other people. And that is admirable, right? But if everything is really about you, who cares about the client, then that would be a little bit questionable. Multiple relationships. When a counselor relates to a client in a professional role and concurrently or sequentially occupies one or more other professional or non-professional roles with the client. So let's break that down really quickly. So multiple relationships means more than one, right? So when a counselor is going to work with a client concurrently, which basically means at the same time as having another relationship with them, or sequentially. Sequentially here means you are now, or you were that person's counselor, and then they quit, and now you are working with them in a different relationship or have a different type of relationship. So that means you could be friends during or after. Intimate partner, which basically means that you're having sex with them or having a romantic relationship with them. You're a peer with them, so you hang out together and in more kind of a professional way. And then also financial partner, so you might invest in their crypto or whatever it is. So if this happens, it becomes multiple relationship. So during or after termination of the relationship, the professional relationship, that could potentially be an issue. All right, not all multiple relationships are harmful or unethical, but some can be devastating. So sexual relationships with a client is illegal in pretty much all states now. Most consistently violated ethical standard among psychologists, second most common with counselors. So as you can see, it happens. Okay. The ACA says that there must be a 5-year period between professional and intimate relationships. So what the ACA is saying is, let's say that you are a client with Maria, okay, and it is 2025. So after you end in 2025 the counseling relationship, should not be until 2030 when you can start dating this person. Okay, that's 5 years. In some other code of ethics, it's 7 years. So find out what it is so that you know that you're not being examined through that and then potentially lose your license to practice. Okay. Let's see, can the counselor list potential harms that can still happen to the client? And I hope that you can think of it. Part of it is now you know a lot of their vulnerable information, so you can manipulate them. And that is not considered ethical. Okay? There's more things. We can have a conversation in class if you want about that. All right, there are 6 principles for counselors to consider. So there used to be 5 for a very, very long time, and then they added a 6th one. So now we have 6, okay? So let's look at those. Beneficence is to do good, promote well-being and health, okay? Like benefit, so to do good. Non-malfeasance is to do no harm, prevent harmful actions and effects. So just think of the word maleficent. M-A-L is typically bad in certain languages, right? So non-malfeasance basically means that you're not doing bad or doing harm to other people. Autonomy means to recognize and respect independence and self-determination. Think about the word autonomous car, which is a car that can drive itself. So autonomy means you're able to make your own decisions. Okay, that's your client. That's what we're talking about. Justice, to promote fairness and equality in dealings. So let's say that you have a client and they qualify for, let's say, a bus pass. Your other clients should also be able to apply and qualify for a bus pass as well, if they're very similar in circumstances, right? You cannot just give it to one person but not to the other. Everyone who should be able to receive it should be able to receive it. Fidelity, be responsible to clients and honor agreements. So fidelity, like Fido is like a term for a dog because the dogs are considered very loyal, right? So fidelity is to be responsible to clients and honor agreements, to be loyal. And then veracity, which is the last and the newest one, is to be truthful and honest in dealings. So ver usually means truth, right? And so to be truthful and honest in the circumstances that we're talking about. Professional responsibilities. Counselors have the responsibility to their clients and must be accountable for client welfare and rights. So once you receive a caseload, right, of clients, you are now responsible for them. And you should be responsible because this is your job now. Malpractice claim is a breach of confidentiality without appropriate justification. So there could be a lawsuit if you share information about your client that you should not be, right? So keep it private, keep it professional, do not share things. I would encourage you to, whenever talk about a case or something, just say, I have a client, and then from there, that's it. You don't have to name them, gender them, or anything like that, because we do not want them to be identifiable, right? And that's professional and respectful. All right, counselors have a responsibility to the public, to other professionals, to agencies and institutions in which they work, and to the counseling profession. So these are the areas where we hope that you are going to be professional and, be your best, okay? You must be competent, which means that you must be knowledgeable about what's going on. And that part of that is experience and also education. You have to respect your client's rights because everyone has their rights for certain things when they enter into a helping professional field, and your clients will be receiving that. Maintain confidentiality, which basically means do not tell anyone anything about their client, and promote client welfare, which is basically help them be their best. Okay, the importance of multiculturalism and ethics. A universal approach, having ethical codes that reflect what is common across cultures while honoring the ethics of each individual culture. So here it gets a little bit more complicated because we're such a diverse community, okay? So we have the code of ethics that we need to adhere to, but we also want to adhere and respect people's differences and uniquenesses. Beginner counselors, cultural insensitivity, racism, oppression, and discrimination are seen as wrong, right? They're unaware of subtle ways, though. How about microaggressions? What microaggressions a Caucasian counselor says to an African American may not be noticeable to the Caucasian counselor, but picked up by the African American client and affect the working alliance. So when it comes to microaggressions, what we're saying is you might say something that you think is really nice or complimentary, but really it's an insult because it's reminding the other person that they are a minority in a negative way. So for example, when, let's say, a white person will talk to a black person or an African American person and say, wow, you speak really well. Because even though it sounds like a compliment, it's saying it's like, I usually don't expect black people to speak very well or communicate very well. So you are out of the normal when it comes to black people talking. So can you see how that might be seen as a microaggression, right? Sounds like a compliment, but it is actually kind of an insult, right? A stereotype. And so that's what they're talking about when it comes to being understanding of who you are as a person, and also how you communicate with other people. Multicultural competency is really important. Unethical towards their client, they might discriminate, harass, or demean. Demean is basically just putting someone down, okay? On the basis of culture, race, ethnicity, religion, gender, sexual orientation, or socioeconomic status. Socioeconomic status, or SES, is basically your class or your wealth, okay? Do you have money or not? All right, it is important to recognize that everyone feels pain, but pain is felt differently in different cultures. Multicultural competencies involve three main components, which are number one, an awareness of one's values or cultural values and biases. Number two is cultural awareness of your client's worldview. And three, using culturally appropriate counseling practices. So let's look at these things really, really quickly. So an awareness of one's cultural values and biases. So you were raised in a specific way. Let's say you were born in America and raised in America. You see America in a very specific way. But you also see how other people are in a different way as well. Maybe your parents told you, hey, you should avoid this group of people because they're dangerous, right? So now you might avoid that group of population. You might not have that many friends in that population or something like that. And part of that is because you have been biased by how you were raised. It's not a good thing or a bad thing in that sense of your parents, because your parents were raising you the way they thought you should be raised, right? So, but what you can do now that you're an adult is to go, you know what, that was not true, that was wrong, and I will not follow that, right? And so that's when we're talking about recognizing your biases and putting it to the side, okay? My mom and dad told me a lot of things because they're very scared of the unknown or the people who are different than them. And so I was raised to be afraid of everyone and to avoid everyone besides only our ethnic culture. That's it. And, you know, that's not necessarily healthy in America because we're such a diverse world and there are awesome people in every ethnicity, you know, that exists. So for me, you have to realize those things, or I have to realize those things. And then I put it to the side, but I admit to it, right? Like, oh, yeah, I was raised to see a certain group of people to be scary or whatever. And, but I don't believe in that. Okay. Cultural awareness of your client's worldview. So you need to also be aware that your client has that perspective as well. So let's say that that person is a Hispanic or Latino person and the counselor is white. They might see the white counselor in a very specific way as well, right? And then three, using culturally appropriate counseling practices. So for some cultures, maybe having religion as part of the discussion is really important. So if you don't know a lot about a specific religion, I would encourage you to be honest with your client and let them know, but also seek out some education about those things, about those religions, right? Start off even before you meet people so that you can learn about all the differences that exist in the world. Counselor competence. Professor responsibility to foster your learning of these aspects of competence and provide ongoing evaluation and appraisal to address the inability of some students to achieve counseling competencies that might impede performance. So that's a lot of words, but basically what it says is your teacher is here to help you, okay? Your teacher will probably notice that you might need additional assistance with cultural competency or competency in general. So we might offer additional assignments. We might talk about it in class, or something like that. And the reason why is not because your professor hates you. It's because we want to make sure that we address what we notice with our students because we want our students to be the best. Okay. Counseling educators assist students in securing remedial assistance when needed. So what that is saying is we try to get you additional help if we feel like you need help. It is not a punishment, and I hope you don't think and see it as a punishment when we ask you to do certain types of things, okay? Start to go, oh, I wonder why. Oh, okay, I think it's because my instructor wants me to do better, right? Recommended dismissal from the training programs when supervisees are unable to provide competent services. So as you go through training, you might realize that helping people is not what you want to do, right? Or you only want to help a certain group of people, but not other people. Counseling in general means that you're supposed to help all your clients, okay? So if you were going to be discriminatory, basically meaning like I don't work with certain groups of people, that could be very, very problematic when it comes to the professional field of counseling. Okay. And we'll explore different things. If, let's say, you're very religious and you want to stay within a religious arena, we can talk a little bit about that later on. Okay. Once a student graduates, it's a graduate's responsibility to remain competent. So once you graduate from our program, let's say you get your master's, you will probably also get licensure certifications. And during that time period, they're going to ask you to continue to learn and to show proof. So that means reading journal articles and then responding to questionnaires and surveys, and also attending conferences and potentially also presenting at conferences. If the professional is not competent to treat a certain client problem, number one, limit services and refer clients to other helping professionals who can meet the needs of one's client in a given area, and then consider expanding one's own competence base. So basically what that's going on is if you cannot help a certain group of people, you should refer them, but then you should also start learning about it so that you become more competent. So you don't have to refer them in the future. Okay. Give the client options to professionals to choose from. So when you refer them also, you have to let them choose, or you should let them choose who they might want to talk to. Okay. Number two, suspend services and refer to several appropriate professionals while you receive sufficient training and supervision in a specialty area. So here, suspend services basically means don't become a counselor, don't work in this field until you are ready to help people and work in this field. Okay. Three, terminate professional responsibilities and make appropriate referrals. So again, you just stop and then you refer them, and then that's it. Okay. Four, if there is no one to whom the counselor can refer, the counselor should seek education in the presenting problem and seek supervision of the work within that client. So as you can see, these are kind of like different alternatives of stopping for a little bit or stopping permanently until you are properly trained. Okay. And don't hate yourself for being not properly trained, but in school, you are given options or opportunities to be trained. And also your internship, you should have been offered opportunities for being trained as well. And we're hoping that you take those things seriously and learn from them. Client rights and welfare, confidentiality, privileged communication, and informed consent is the next section that we will be talking about. All right, privacy and confidentiality. Confidentiality and privileged communication. So we're going to do some vocabulary word learning right now. Privileged communication is a legal term referring to the right held by clients to prevent therapeutic information from entering into a legal proceeding. So what that is saying is, let's say you have a client who's getting a divorce and is trying to get custody of their children. Okay, so the courts might call you in from the other person in this relationship. If that happens, right, you do not have to share any information because your client says do not share any information. So you can say, this is privileged communication and I cannot reveal this stuff. However, there are ways where it can be revealed, okay? Clients, not the counselor, have control over who has access to what they have said in therapy. Clients are protected from having their communication disclosed in a court of law. So unless the client says, hey, you can do it and release it, you have to sign paperwork and stuff like that that releases it. And then once that happens, then you are able to talk about what is said in therapy or in counseling. All right, note, not privileged communication if the mental health professional is not legally certified or licensed in the state of practice. So this is just a little note. You know how on social media there's a lot of coaches or life coaches? Coaches is not a real profession. Anyone can call themselves a coach. You can call yourself a coach if you want to. I can call myself a coach if I want to. Some coaches are actually legal, certified professional counselors who are also coaches as well. But a coach themselves does not make them a counselor or does not say that they're trained. Okay. So if they're not a person, if they're not a person that has responsibilities to a profession, a field, a code of ethics, then they can talk out loud without having to say this is privileged communication, because there's no laws holding them responsible for certain conducts. In order for communication to be privileged, number one, communication must originate in confidence that it will not be disclosed. So, in a professional therapy or counseling session, on the first day, there would be an informed consent, which will talk about privacy and confidentiality. Okay. And so if that is part of it and they're aware of it, then that is great. Okay. That means that we will not share. Obviously, there are some minor exceptions, such as, let's say, the supervisor, you're an intern, your supervisor will probably know and read case notes and know what's going on between you and your client, right? Or if your client says that they're abusing someone, either a child or an older adult or a person with a disability, then those things can also be reported to, let's say, the police. 2, confidentiality must be essential to the full and satisfactory maintenance of the relationship. Typically, clients will not talk to you unless they know that you're going to keep everything between you two. If they know that you are a gossip, why are they going to tell you anything, right? Or maybe they might lie to you. So again, confidentiality is so important to be established in the professional field. 3, in the opinion of the greater community, the relationship must be one that should be noted by care and persistent effort. And so that means you have to work at this relationship. Okay. 4, injury to the relationship by disclosure of the communication must be greater than the benefit gained by the correct disposal of litigation regarding this information. So what that is saying is, typically we're going to hold everything private unless it's going to harm someone else or themselves, or the client themselves. So if they're saying they're going to go kill someone, then we now need to break the confidentiality rule, right, and report it to the people. Okay. If a client waives privilege, the door for privacy is unlocked. So when it says waive privilege, that means that they're going to sign off paperwork that says that they allow the therapist or the counselor to talk about this, their counseling in the court system. Counselors who encounter a request or requirement to participate in a legal proceeding should consult with an attorney. So you should still talk to an attorney just to make sure everything is okay. If you work for an agency, see if you can have them talk to their lawyers or their legal people, because maybe they can help you and you don't have to hire one yourself. HIPAA and the privacy rules. I'm sure you all have heard of the word HIPAA, but you might not know a lot. So we're going to learn about it right now. In the 1990s, concern over the privacy of health services consumers increased due to technology. So technology that we're talking about is the fax machine, okay? Remember, in the 1990s, there were no emails really, no text messaging really. Those things did not exist yet, okay? So what happens is a fax machine is kind of like a printer, a phone printer, basically. And you would send information through the machine and it would print out at the other place. Typically, those fax machines could be in the area where the administrative assistant person is, right? Or the receptionist person is. And so it's kind of public-ish, right? So we want to ensure that the people who work there, when they pick up information from the fax machine, that they respected the personal information in there, okay? This comes from the U.S. Department of Health and Human Services, created the Health Insurance Portability and Accountability Act. So because things are being sent through fax machines for multiple people to one fax number, right? We wanted to make sure everyone was on the same page when it came to confidentiality and privacy, to ensure privacy of consumers while at the same time allowing for efficient transfer of information. Okay, so the Health and Human Services Privacy Rule is use and disclosure of client information termed Protected Healthcare Information, or PHI. Information on any past, present, or future mental or physical health of clients, including payment information, should remain private and respected. Any information that might or can be used to identify a person as well. And there will be information that would identify it back then. Okay. Now we see emails, or we'll have personal deliveries, signed deliveries and stuff like that. And there's also new forms that talk about certain types of reasons why this person's getting the information and for how long does this remain valid. Okay. Exceptions to confidentiality. So these are the times when you are permitted to break confidentiality and privacy. 3 global issues that require a breach of confidentiality. Number 1 are minors. So minors are little kids, right? Further harm or continued abuse of or neglect of those children. So that means physical harm, sexual harm, or ignoring them and not taking care of them. That would be neglect, okay? Number 2, incapacitated and vulnerable adults. So these are adults that might have mental illness, mental deficiency, mental disorder, physical illness, or disability, or they might be older, that's what advanced aged is, chronic use of drugs, chronic intoxication, lacking sufficient understanding or capacity to make a communicated, responsible decision. So if they're not able to because it's affecting their, let's say, their thinking, that would be another vulnerable group. And that if you were abusing them or the client was abusing them, we would report. 3, serious and foreseeable harm to self or others. The counselor overriding responsibility to protect an intended identifiable victim from harm that could result in a client's action. So the one that's really well known in our field is the duty to warn or duty to protect, which is a Tarasoff versus the Board of Regents of the University of California, Berkeley. There's a link right here if you want to go onto the PowerPoint and click on the link and read it, or you can just type in Tatiana Tarasoff or duty to warn, and you'll be able to read the article about it. But basically what happened was, at UC Berkeley, there was a student who was in love with another student. Let's say his name was Podar, his last name is Podar, and her last name was Tarasoff. So Podar told his therapist at school that he was going to kill Tarasoff. So the counselor, the psychologist, called the campus police, and the campus police went over and interviewed Podar, and he sounded pretty normal. That's what they're basically saying, so they let him go. And then the boss of that therapist said, oh yeah, well, we're good then, right? But no one warned Tarasoff, who was on vacation, right? They couldn't find her. Again, this was in the 70s, I believe, so there's definitely no cell phones yet or anything like that. And so when she came back to school, he killed her. So there was a lawsuit, and this duty to warn came out of it, okay? So you want to make sure that there are things that will protect other people if I would say our client is threatening them. So if that does happen, what you want to do is you want to let the client know. Well, you need to let the intended person that the client wants to harm know. You need to also let potentially a family member of that person who might be harmed to know as well, and then also call the police as well. So there are 3 ways. You might even want to go find that person and then let them know yourself. That's another way of finding that person. Obviously, with cell phones and internet and all that stuff, it's a lot different than back in the 70s, right? So please feel free to read up more on the Tarasoff duty to warn. Exceptions to confidentiality when the clients introduce their mental condition as an element in a court case. So they might say, this is kind of like the term is, have you heard of I plea insanity, right? So what that is saying is that I have a mental health issue and this is why I cannot make the right decisions. So if that happens, then you are able to also talk about it in court. Mental stability of either spouse is introduced in a child custody case. So when people get divorced and there's children involved, it can get really dirty and nasty, right? And so they're going to go, well, you go to therapy, that means that you're crazy, right? So that they can get the spousal or the child custody, right? Or maybe spousal payments or something like that. When the counselor is working for the court, such as in conducting a court-ordered evaluation examination, so let's say that there are 2 clients and then the court needs to know whether or not these clients are able to sit and proceed and understand what's going on in the court of law, then you'll evaluate them, and so then you have the right to reveal what the results are. When the client is suing the counselor, so when the client is suing the counselor, obviously that means that they've broken confidentiality because they know that this person is receiving services, right? So then you can also talk about it then. And when the counselor believes that the client is in need of immediate hospitalization. So if the client is a harm to themselves in one way or another, you might have to report them, get a triage of some sort, the hospital, the police, to do an involuntary commitment, also known sometimes as the 5150. So that they are not going to harm themselves. Okay, confidentiality in HIV. Dilemma between protecting the client's rights of confidentiality and the duty to warn when clients do not inform their sexual partners of their medical condition. So in the ACA, it says that when a client discloses that they have a disease commonly known to be both communicable and life-threatening, so what that means is you can spread it, right? And people can die from it. Counselors may be justified in disclosing information to identify third parties if they are known to be at high risk of contracting the disease. This means practice of disclosure may be permissible, but it's not necessarily legal or mandated. Unless there is an identifiable victim and the client refuses to behave in a manner that protects the person, the covenant of confidentiality should not be broken. So in California, if your client has HIV, right, you are not allowed to break that person's confidentiality to a person that they might be having sexual relationships with. Okay, so in California, what we're saying is that HIV is no longer a death sentence, number one. People live very long lives now if they take care of themselves and take the proper medication. But also, it's no longer a felony. It is a misdemeanor. And that basically you cannot break confidentiality to the other person. We're hoping that the other person is going to be responsible for themselves. They should talk to their partners about sexual transmitted diseases. They should also protect themselves, using protection and stuff like that. There's also medication that prevents people from getting HIV, known as PrEP, right? And so that's another opportunity for them to also consider to protect themselves as well. All right, informed consent. There are 3 elements to informed consent, which is typically a form you start at the beginning of your counseling relationship. It's competence, informed, and voluntariness. And we're going to go through those in the next slide. All right, competence. Able to engage in rational thought to a sufficient degree to make competent decisions about his or her or their life. So competence basically means that they understand what's going on around them. Minors cannot give informed consent. They must get consent from their guardians, okay? So their parents typically is where they're going to get permission. Minors can give assent. So basically they're saying is that, yeah, I'm willing to participate, right? But they cannot give informed consent because children might not understand all these words that are in a contract, okay? Informed person is given relevant information about the procedures to be performed in a language that he or she or they can understand. And then voluntariness basically means that consent is given freely by the client. So the client wants to do this. And they know that they can not do it anymore. They can stop therapy or whatever it is if they want to. They have the right to. Okay? All right. Inside an informed consent form are the purposes. So why are you coming to therapy or receiving services here? The goals. So that is, what are you trying to reach? The technique, so it might be your counseling theory style. The procedure, how is this going to go, like how long it might take for this therapy to, before you're able to reach your goals. The limitations, so the reality is that when you go to therapy, it's not 100% guaranteed that you're going to get better, right? So there's sometimes limitations when it comes to that. And to be realistic, to be grounded and say, it might work or it might not. We don't know, okay? We cannot make any promises that we cannot keep. Potential risks. So let's say that for some people, if they take medication, they might have side effects, right? So these are some of the risks when it happens when it comes to therapy and or medication. Benefits of the services. So benefits would be, you reach your goal and you're a healthier, happier person. Counselor's qualifications. So we share what kind of degree education we have, maybe our area of interest that we work with and stuff like that so that the client knows. Credentials, so that might be degrees or certifications that people have. There's a thing called an LPCC or an MSW. All those types of things are considered credentials. Relevant experience, so you might talk about the people you've worked with, how long you've worked in the field. Continuation of services upon the incapacitation or death of a counselor. So, hey, we're going to be in counseling. However, I'm pregnant right now and I will have a child in 6 months, right? So if that happens, let's say maybe in 5 months because there's an issue, this is what's going to happen with you because we do not want to abandon you, right? We're going to move you over to this therapist in this agency and then they will carry on from there, okay? Or maybe if the therapist decides that they're going to move to another state or something like that, what happens, right? Again, we'll probably refer you to another therapist or counselor in this agency, and then we'll, make sure that you'll be set up and you're not going to be feeling like you've been abandoned, okay? And then any other additional permanent information, typically that would be like billing and stuff like that. All right, counselors make sure that the client understands the implications of a diagnosis. So once, let's say, we diagnose you with something, that it's going to mean a lot of things to you emotionally and also, professionally as well, potentially, right? Because it could be in your medical records. The intended use of the test and the reports, the fees, so that means the money, and then the billing arrangement, how are we going to arrange for those fees to be paid? Because as a counselor, as a therapist, or whatever, you should get paid for your job, right? There are limitations, clear information about their records, to participate in ongoing counseling plans, to refuse any services or modality change. So that basically means that the client goes, you know what, I don't really like this technique that we're using. Can we change it? And they have the right to say that and a right to change it. To understand the consequences of any of those refusals. So let's say that the therapist has offered a lot of help and the client goes, you know what, I don't want any more help. So if they end it there, the client must understand that if they refuse to work together, that they're not necessarily going to get any better. Okay. Couples and family and group work counseling ethics. There are key differences when working with couples and families. You want to ensure group confidentiality and to appropriate treatment of the family as a group as well as members of a group. So it is going to be a little bit more complicated when it comes to families because everyone knows each other personally, right? Whereas a group where people meet there and then become, let's say, acquaintances that way. Counselors are not to disclose confidences or secrets provided by one member in an individual session to other members of the group or the couple or the family without consent. So that means that sometimes you're going to meet a family, but then you're also going to meet them one-on-one just to check in, let's say, right? So whenever they reveal anything in those one-on-ones, you cannot just share it with a group without permission. Counselors must be clear that the primary client is the family, and counselors must take care to get informed consent from each of those clients. And typically, before you start, you will say all these things so they know how everything is going to unfold, what can be said in privacy, and what will be said in, let's say, shared amongst the group. Ethics is applied to group types, group management, communication of group parameters. So the purpose and goals of the group should be clear. So typically when there is a group session, it is talking about something that probably they all share in common. So let's say it might be grief work, right? Which is trying to get over a death of a loved one. And that's why they're all there. Okay. So they probably all have very similar goals and purpose from why they're there. Group work must monitor progress of the group goals. Counselors cannot assure that the group members will maintain group confidentiality. That's a big one. So when we did one-on-one counseling, we can say, you know what? I'm not going to share any of this information. Okay. However, when you're doing a group, the counselor can only promise themselves. They cannot promise that the other, let's say 7 other people are going to keep it private either. Okay. So that means that we cannot promise confidentiality in group sessions. Okay. We can encourage them and remind them that we're all adults, we're respectful, we're all here to help each other. So we want to make sure that everything is private, right? But there's no way that we will know whether or not 2 of the people in the group will hang out with each other after sessions, right? Or 5 of them will hang out together. We do not know. So we do not know what's going to happen, if they're going to talk out loud with each other or someone else might be able to hear. So confidentiality in a group session is not possible. Group workers apply and modify knowledge, skills, techniques appropriate to group types and stages, and to be multiculturally sensitive. So again, all the therapies that we typically know about, like let's say Freudian versus person-centered versus Gestalt or existentialism or feminist therapy, all of them typically are talking about one-on-one, but they can be applied into group sessions as well. Individuals in group counseling need to be screened before being accepted into a group. So to make sure that each person is an appropriate person for that group, protect members from dysfunctional group members. So let's say, for example, I'm going to have 8 people who are going to go into this group. I'm going to interview each of those people to screen them to make sure that this group is going to be cohesive together. Because if we have one person who's going to talk the entire time and not let anyone else talk, that could be problematic, right? So that person might be one-on-one for a little bit so we can share how we can learn how to be respectful and also listen and take turns, right? But we also don't want 8 people who are all quiet either. So we definitely need to screen to make sure that the groups that we have work well with each other. School counseling ethics. School counselor ethics are impacted by federal laws related to academics and education. So when it comes to schools, depending on if it's children, minors, it will have its own set of rules as well. Okay? The Family Educational Rights and Privacy Act, also known as FERPA, guarantees certain rights to parents of students to protect and have access to their clients' information. Counselors working in schools may have additional challenges around them, maintaining and breaching confidentiality, because it's different from working with other people. Since they are minors, requires parents to participate. That could be helpful, or it could be very complicated because parents might want to join in on certain things that should be more one-on-one with the client. Maybe it's about the parents, and the parents want to know why, so then it can be complicated. Counseling and group work may take place in a classroom or rooms that are not meant for counseling. So that could also change things because maybe it's a really large room. It might change the feel, the mood, the privacy, and stuff like that. Okay, and the last section we're going to talk about is technology-assisted distance counseling ethics. So this is online therapy, basically. Number one, counselors consider the appropriateness of online counseling and address limitations or misunderstandings. So imagine a web camera, right? If we don't see your entire body, we might misunderstand how you are feeling at that moment, okay? When I can look at you in front of me with your entire body, maybe you're tapping your foot, that might mean that you might be a little bit anxious or something like that. We can really understand who you are with a better understanding and estimate or hunch. But whereas if it's just a screen, then we might not necessarily know because all we see is your chin above, right? 2, counselors explain the limits of confidentiality, particular to online counseling. So here's another thing. We don't know who else is in the room with you in your while you're doing therapy. So your parents might be there. So if your parents are there, you might then answer questions differently than if you were alone, right? So we cannot know how private it is. 3, counselors explain and notify clients about certain aspects of how confidential information is handled, because who has access to these computers? And that might be an issue as well. Are people going to be able to access your email, right? If we're emailing each other and stuff like that. 4, counselors use security technology, software, and secure sites to protect client information and communications such as encryption, firewall technology, digital shredders, password protection for computers and files, HIPAA-compliant web conferencing tools. So this stuff is typically what we do. However, because of the pandemic, things went a little all over the place because you were expecting everyone to do therapy online, and that was a lot of people, right? So FaceTime was allowed, Zoom was allowed, but typically Zoom and FaceTime are not allowed. Okay, so things are kind of in the middle right now, I would say. But typically, if you're working at a professional agency, they will have specific computers, specific websites that they use to make sure that confidentiality is still maintained. All right, 5, professional counselors identify foreseeable situations in which confidentiality must be breached in light of the law in both the state in which the client is located and the state in which the counselor is licensed. So what that is saying is, let's say you're using BetterHelp or something like that, and your therapist is in Mississippi and you're in California. What happens now? Is the laws that are applied to Mississippi or the laws applied to California that we're working with, right? Both people know? Because maybe one side is mandated and one side is not mandated or duty to warn. So what happens there, right? It becomes an issue. 6, professional counselors identify clients, verify identities of clients, and obtain alternative methods of contacting clients in emergency situations, including identifying local alternative professional help in case of a crisis. So that question is, let's say that your client is suicidal. What do you do if they're in a different state? You need to make sure that they are who they say they are, that you can actually know what their address is, because they might say that they live here, but they're not really there. Then that becomes another issue. You know, I hear a lot of people doing therapy in their car, right? So how are we going to be able to find you if that's the issue there? 7, there are certain circumstances in which a client must waive a right to privileged communication because of the nature of online services. So again, there are some concerns when it comes to technology because it keeps on changing so much. 8, find cost-free sites for clients when possible. Be aware of the client's local environment and culture, as well as provide a barrier-free environment for clients with disabilities. So ultimately, online is fantastic for people with disabilities because if they cannot navigate like the city, maybe the buses or the car services are not accessible to them, it is so fantastic that they can do this all online, right? And that they don't have to spend money for gas and stuff like that. However, there are pros and cons to this. So we do that, but we might not necessarily get the full understanding of who you are as a person because we do not see your nonverbal language, body language, and stuff like that, plus additional other things like privacy. All right, we're done with this chapter. Thank you. Bye-bye.